I think so. Well, Rob, let's take this.
The best one.
Yeah, well.
Good evening, everyone. Welcome you tonight to the Judge Guido Calabresi Fellowship in Religion and Law. Honoring Judge Calabresi, former Dean of Yale Law School and a member of the Board of Trustees at STM, tonight it is my pleasure to welcome our speaker, Judge John Koeltl. Judge Koeltl was appointed U.S. District Judge for the Southern District of New York in 1994. He received his undergraduate degree from Georgetown University and his law degree from Harvard Law. Early in his career, Judge Koeltl served as an Assistant Special Prosecutor for the Watergate Special Prosecution Force from 1973 to 1974. He served as associate, then partner for Debevoise Plimpton from 1974 to 1994, when he was appointed to the bench. He also served as adjunct professor at law at New York University School of Law. Please help me to welcome Judge Koeltl as he addresses the topic, religion and judging.
Thank you. It's truly an honor and a privilege for me to talk to you tonight for so many reasons. It's an honor to speak at a lecture that's named for Judge Calabresi. Judge Calabresi has received numerous honors and distinctions. He is one of those few people in the legal profession who is instantly recognized solely by his first name, Guido. But most importantly for me and for this evening, he is truly a person for others, to borrow a Jesuit ideal. Judge Calabresi has dedicated his life to teaching students, to serving the public interest by being a judge, and by advancing legal scholarship through his writings. To speak at a lecture named for Guido is a high honor and somewhat intimidating. I could not praise Guido without also recognizing Anne. What an extraordinary blessing that Guido and Anne found each other. I cannot think about Guido without thinking about Anne. What a wonderful couple and a wonderful family. I look forward each year to Anne's Christmas letters, which Guido generally joins, at least for those non-political sentiments that he can associate himself with. I can still remember one Christmas letter where Anne quoted Teilhard de Chardin, the Jesuit theologian whom I had not heard of since I graduated from Georgetown. It was very moving. And so to Guido and Anne, thank you for asking me to do this. It's really a privilege and honor. You're such superb people. It's also an honor for me to speak at Yale. I clerked for two great judges, Judge Edward Weinfeld on the Southern District of New York and Justice Potter Stewart on the Supreme Court. Both of those judges showed me the joy of public service and were the inspiration for my own aspiration to become a judge. Justice Stewart is inseparable from Yale in my mind. He received his undergraduate degree from Yale and his law degree from the Yale Law School in 1941. He was at the Yale Law School at the same time as President Ford and Justice Byron White, and all were part of that great generation that served courageously in World War II. Yale was always important to Justice Stewart, and I was privileged to attend the inaugural lecture for the Justice Potter Stewart Professorship at the Yale Law School. And so, by speaking here today, I honor Justice Stewart because Yale meant so much to him. The topic for my remarks is religion and judging, but it could well be subtitled Personal Reflections by a Catholic Federal Trial Judge. I do not presume to talk about religion in the lives of other judges, and certainly not judges who are not trial judges. I also do not profess to be a theologian. I speak only from personal experience for having been a federal trial judge for over 25 years. Some words of background may be useful. I went to a parochial grammar school taught by the Sisters of Charity. I then went to Regis, a Jesuit high school in New York City, a great high school where the Jesuits imbued the importance of Christian service and where the mantra was to form, quote, men for others, unquote. That concept of service certainly must have borne fruit. At one time, there were 4 graduates of Regis who were judges on the Southern District of New York, my court. And I doubt that that could be matched by any other high school in the city. And then I followed the Jesuits to Georgetown. I remember, thankfully, the nuns, priests, and Jesuit scholastics who taught me over the years. And so I have plainly been steeped in religious tradition and training that surely informs me as a person. When I applied to be a federal trial judge, I was interviewed by a small subcommittee of Senator Daniel Patrick Moynihan's nonpartisan selection committee. One of the interviewers asked me why I wanted to be a federal judge, and I responded about my desire for public service. The interviewer then said, well, I hear what you say about public service, but I'm not sure I see so much public service in your background. I responded by talking about my clerkship, my work at the Special Prosecutor's Office, and work over the years with numerous Bar Association committees. And then the interviewer said, well, I hear what you're saying, but I saw that you were a trustee of Regis, and I would have expected more work in soup kitchens. So I talked about personal charity and then ended up by saying, but none of us does as much as we should. A little cheeky in retrospect. So after the interview was over, I asked the interviewer, how did you know about Regis? And he said, oh, my son went there. So you see, Regis was probably one of the reasons that I eventually became a judge. Some might say that religion should have no part in judging, and if religion is viewed narrowly as dogma, they would surely be right. Justice Scalia once said that, quote, just as there is no Catholic way to cook a hamburger, he would be hard-pressed to think of an opinion of his that would have come about differently if he were not a Catholic, unquote. But while religion cannot and should not dictate the result of a case, religious values shape us as people, and we bring the experience and background of our lives to the task of judging. So I would like to talk particularly about 3 religious values which are also ethical or moral imperatives. First, fidelity to the law. Second, mercy, compassion, or empathy. And finally, humility. All of us have an obligation to follow the law, and judges in particular have an obligation to apply the law as it exists, not as they wish it to be. Judges are not legislators or politicians. Federal judges are not elected. They are not responsive to the will of the people. In their professional lives as judges, judges have an obligation to follow the law that exists. And that law must be followed, civil and criminal, but not canon law. As St. Paul wrote to the Romans, let every person be subordinate to the higher authorities, for there is no authority except from God, and those that exist have been established by God. Plainly, our religion teaches us that we are all required to follow the law as it exists, and this religious command is particularly acute for judges who administer the law day in and day out. And the law that we must follow and interpret is the Constitution, statutes, and common law, whether we agree with them or not. When the federal government began to enforce the death penalty some years ago, and when the first death penalty cases were beginning to be brought in my court, I recall one of my devout Jewish colleagues commenting, quote, "If you're not prepared to follow the law, you should resign," unquote. And one of my dear, now deceased colleagues, Richard Casey, a devout Catholic, had a famous case challenging the constitutionality of a federal statute that banned partial birth abortion. Judge Casey presided over a 16-day bench trial. At the end of the trial, Judge Casey found that the practice was, in his words, quote, "a gruesome, brutal, barbaric, and uncivilized medical procedure," unquote. But under the Supreme Court precedents, Judge Casey found that the federal statute banning the practice was unconstitutional. The Supreme Court eventually found that the statute was constitutional in a closely divided vote, 5-4. But at the time Judge Casey decided his case, he was required to follow the law as he believed it to be. As Justice Scalia wrote about Judge Casey, and they were good friends, Judge Casey did not confuse his personal views with the law, and he knew that he sat to pronounce the latter, not to advance the former, unquote. Justice Scalia continued, quote, "I am entirely certain that before the only judgment seat that really matters, he scored high points for unbending fidelity to his judicial oath," unquote. But that, to me, is really the central point. While religious dogma cannot dictate how a judge should rule, religious values form the character of the judge. Part of that character must be fidelity to the law in accordance with the oath that we take as federal district judges. Article 6 of the Constitution provides in part that, quote, "all executive and judicial officers of the United States shall be bound by oath or affirmation to support this Constitution, but no religious test shall ever be required as a qualification to any office or public trust under the United States," unquote. As Judge William Pryor of the Court of Appeals for the 11th Circuit wrote, quote, "the framers thought that the particular religious beliefs of the judge should not matter, but that it was crucial for the judge to have his conscience as informed by those beliefs bound by the Constitution," unquote. The oath that federal district judges take requires us, quote, "to administer justice without respect to persons and to equal right to the poor and to the rich, and that I will faithfully and impartially discharge and perform all the duties incumbent upon me as a United States District Judge under the Constitution and laws of the United States, so help me God," unquote. That oath was adopted in the first Judiciary Act of 1789 and has been taken by federal judges ever since that time for over 200 years. The oath itself dates back to biblical injunctions in Leviticus and Deuteronomy. So, what is the law that we must follow? Our oath directs us to the Constitution and laws of the United States, but that is hardly self-explanatory. I have a very simple analogy, and it's probably influenced by a man for all seasons, so please bear with me. I know that I have been using this analogy from the days I became a federal judge, because I remember discussing it with the attorneys at the Department of Justice who vetted me during the confirmation process. So my view of the law is that the law is like a tree. It has a very large trunk, the Constitution and statutes. It has large branches that grow from the trunk, and ever smaller branches leading to twigs. Those branches and twigs are all of the decisions that have been issued interpreting the Constitution and the statutes and the laws. My job as a federal trial judge is to find the most relevant precedents in order to answer the question of what the Court of Appeals or the Supreme Court would tell me that the law is in the case that I have to decide. I always tell my law clerks that if we work long enough and hard enough, we can always find the more correct answer. I remember a Justice Department lawyer in that vetting process asking, well, what if you can't find a twig? And the answer is, you ask yourself where the nearest twig would naturally grow. I should add that the Supreme Court is in a very different position. It has an enormous authority in our legal system to declare that one of those branches looks exceedingly ugly and to cut it off. But that's not my role. The Supreme Court has plainly done that in cases about which there is no conflict, cases like Brown against Board of Education, and in the Katz decision where Justice Stewart wrote for the court that the Fourth Amendment protects people, not simply places, and created a right to privacy under the Fourth Amendment. Those are at least two uncontroversial decisions where the Supreme Court cut off an extremely ugly branch, rejected precedent, and decided to go in a new direction. But that's not the role for a simple trial judge in our system. And perhaps my image of the law as a tree and the importance of fidelity to the law was influenced by A Man for All Seasons, Robert Bolt's 1966 play about St. Thomas More, which I saw when it came out. A wonderful play, particularly in these premises. You remember the scene where St. Thomas More talks with William Roper about the need to follow man's law. Thomas explains, quote, "I know what's legal, not what's right, and I'll stick to what's legal." And Roper asks, "So now you'd give the devil the benefit of the law?" And Thomas responds, "Yes. What would you do? Cut a great road through the law to get after the devil?" Roper responds, "I'd cut down every law in England to do that." And Thomas famously explains, "Oh? And when the last law was down and the devil turned on you, where would you hide? The laws all being flat. This country is planted thick with laws from coast to coast, man's laws, not God's. And if you cut them down, do you really think that you could stand upright in the winds that would blow then? Yes, I'd give the devil the benefit of law for my own safety's sake," unquote. And Thomas subsequently goes on to talk about the importance of his oath. Quote, "What is an oath but words we say to God? When a man takes an oath, he's holding his own self in his own hands, like water. And if he opens his fingers, then he doesn't hope to find himself again." This rigid adherence to the law, as best we can find it, is the opposite of the flexible approach to the law that simply subordinates the law, as it is, to the judge's view of what the law should be, or to follow up on a different analogy, to subordinate the civil law to canon law or to the judge's personal views of what's right. It is the opposite of that famous scene towards the end of Rodgers and Hammerstein's Oklahoma. You remember, I hope, Curly has killed Judd on Curly's wedding day. It certainly looks like murder, but Judd is not very popular. Judd is an outsider. And the crowd wants to help Curly to get away on his honeymoon, particularly on this wedding day. And so they have a very quick trial and come up with a theory of self-defense. The trial is rushed through in an unsettling not guilty verdict. And then Aunt Eller says, famously, well, let's not break the law, let's just bend it a little. Exactly the opposite of the image from A Man for All Seasons. In short, fidelity to the law as best we can determine it is part of our lives as district court judges. It is part of our religious culture and ethic. It follows the injunction of St. Paul to be subordinate to higher authorities. It is informed by our beliefs that we are required to follow the law as best we can discern it. And if we fail to do that, we are not faithful to our beliefs and to our consciences. It is required by our oath, which itself is dictated by the Constitution and by congressional statute. We can separate religious dogma from our obligation to follow the law, but we cannot separate who we are as people from our role as judges. And who we are as people is influenced by our religious values. One of those values is the importance of following the law. If we bent the law like Aunt Eller, we would not be true to ourselves. It would be odd indeed if the religious values, particularly fidelity to the law, which are so important to us and how we view ourselves as people, were divorced from our professional lives. I'm reminded of a time when one of my former partners came back from a funeral service after having heard a rabbi give a particularly moving eulogy. My partner said to the rabbi, "Rabbi, that eulogy was beautiful. How long did it take you to prepare it?" And the rabbi responded, "All my life." Religious values can be shared by all people of all religions and those who do not profess a religion at all. It really is not necessary to parse out why a person believes so deeply that it is necessary to follow the law. All I say is that I know that part of my own being is fidelity to the law as best I can find it, and that my religion, as well as my oath, demands that I do that. My religion would not tolerate following religious dogma at the expense of following the law as best I can discern it. I'll leave the subject of fidelity to the law with a story from my clerkship with Judge Weinfeld. In the first week of my clerkship, the judge gave me a draft of an opinion that he had written and asked me to edit it. I did the best I could, but there was still a conceptual problem with the draft. But I left the opinion as best I could and left it for the judge that night. The next morning, I came into the office, and there was a new draft on my desk that the judge had rewritten, and it solved the conceptual problem. So I went into the judge's chamber, and I explained in my eagerness as a new clerk that this opinion was really now great. I left it the night before. I did the best I could, but I knew that there was something that was not quite right. And now, this opinion that the judge had done was really good. And I smiled, I'm sure. And the judge looked at me in the coldest possible voice and said, "Don't ever, ever let me do anything that's not quite right." Well, not the best way to begin a clerkship, but a lesson well learned. While Justice Scalia said that there is no such thing as a Catholic judge, he also said that his Catholic faith obliged him to abide by two commands. Quote, "Be thou perfect as thy heavenly Father is perfect. and thou shalt not lie, unquote. When I was drafting these remarks, who knew that perfection, the line about perfection, would be in today's gospel from St. Matthew? Justice Scalia explained that for him, this meant that he would never distort prior cases or the Constitution. These commands are certainly not distinctively Catholic, but they are part of the religious values that we seek to follow. A second religious value that is critical to judging is mercy, which for me is synonymous with compassion or empathy. There are areas of the law where the law provides trial judges with considerable discretion, and religious values, which are also ethical and moral values, can justifiably play a role in exercising that discretion. This is particularly true in the area of sentencing. As a Catholic, I accept that all people are children of God, that we can see God in all people, and that as we do unto the least of our brethren, so we do unto God. And Christ was the example of mercy. Father, forgive them, for they know not what they do. And this day you will be with me in paradise. Justice Sotomayor, another great Yale graduate, ran into some criticism during her Supreme Court confirmation for having expressed empathy for some defendants who appeared before her. But how can you not have compassion for those who appear before you, whether they be defendants or victims or family members? You are called on to take all of these interests into account, whether we call it empathy or compassion or simply mercy. We must recognize the humanity of all people involved in the sentencing decision. I have thought that Congress passed one of the most thoughtful and far-sighted statutes when it passed the Sentencing Reform Act of 1984, which is probably not known to a lot of you, but there it is. Under that statute, a federal trial judge, quote, shall impose a sentence sufficient but no greater than necessary, unquote, to accomplish the four purposes of sentencing, namely, 1, to reflect the seriousness of the offense, to promote respect for the law, and to promote just punishment for the offense. 2, to afford adequate deterrence to criminal conduct. 3, to protect the public from further crimes. And 4, to promote the defendant, to provide the defendant with needed educational or vocational training or other treatment, unquote. Note that this is a requirement of the law. The judge is required by law to impose a sentence that is sufficient but no greater than necessary to accomplish these goals. If the judge imposes a sentence that is greater than necessary, the judge is literally violating the law. What a wise congressional statute. It requires the judge to impose a sentence no greater than necessary. A judge literally violates the law by imposing a sentence that is unnecessarily harsh. Of course, the exact sentence is very much up to the discretion of the trial judge in balancing the four major purposes of sentencing, recognizing the seriousness of the offense, the need for deterrence, to protect the public, and to provide rehabilitation for the defendant. But in reaching that difficult conclusion, the court can very much consider the humanity of the defendant, because the court is required to impose the least severe sentence necessary to accomplish the purposes of sentencing. In recent years, at least in my court, defense counsel have been doing a very thorough job of explaining the particular circumstances of the defendant, their intellectual problems, their lack of educational opportunities, their difficult upbringing, and other circumstances that mitigate the offense and suggest that a lower sentence can accomplish the purposes of sentencing. And if a lower sentence can accomplish the purposes of sentencing, the judge by statute cannot impose a harsher sentence. I'm reminded of a sentence that Judge Weinfeld imposed when I was clerking for him. The judge was faced with a defendant who had pleaded guilty to a white-collar crime. It was the judge's practice to sentence all white-collar defendants to some period of prison because the judge thought it was necessary for purposes of deterrence. But in this case, the elderly defendant was responsible for many acts of anonymous charity during his life. Anonymous acts of charity that the defendant had no reason to believe would affect the sentence years in the future. The judge, paraphrasing Ecclesiastes, told the defendant that the, quote, bread you have cast upon the waters has now returned to you, unquote. The judge, unlike his usual practice, did not sentence the defendant to prison. Mercy. I also recall a recent occasion where I resentenced a defendant as a result of a Supreme Court decision that had changed the law in the defendant's favor. The defendant returned to my courtroom after serving a considerable sentence, and I reduced the sentence to time served. In his remarks, the defendant thanked me, first and foremost, for the fact that when I originally imposed the sentence on him, I made sure that the Bureau of Prisons took care of a serious medical condition that the defendant suffered from and which previously had been ignored. The defendant thanked me for literally saving his life. The opportunity to treat others with dignity and compassion is one of the aspects of being a trial judge that makes the job so satisfying. I would be remiss if I didn't note that there are a series of other statutes that remove sentencing discretion from federal trial judges and require the sentencing judges to impose mandatory minimum sentences for certain crimes, particularly involving firearms, drugs, and pornography. If a defendant is convicted of one of those crimes, the sentencing judge has no discretion and is required to impose a mandatory minimum sentence of imprisonment for many years on the defendant. These sentences are often much longer than the sentences that the trial judges would otherwise have imposed. They run, in some cases, into decades, and they have additional pernicious effects. They encourage defendants to plead guilty to lesser offenses in order to avoid mandatory minimum sentences, even if the defendants would have had triable cases and if they would have gone to trial. One of my colleagues has argued that these sentences encourage even the innocent to plead guilty in order to avoid draconian sentences. These statutes are directly contrary to the wise congressional legislation that leaves sentencing to trial judges and requires the judge to impose the least sentence necessary to accomplish the legitimate goals of sentencing. I recall one case recently where the mandatory minimum sentence would have required a sentence in excess of 35 years imprisonment as a result of a series of robberies, even though no homicide was involved. The defendant refused government plea offers and went to trial and was convicted. I urged the government not to pursue the mandatory minimum sentence, and the government subsequently agreed to a new plea disposition that reduced the defendant's sentence by some 20 years. In another case, I urged the government not to pursue a lengthy mandatory minimum sentence to no avail. But as a result of a recent Supreme Court decision and a fresh look at the case by a new set of prosecutors, the government agreed to a resentencing that substantially reduced the defendant's sentence and resulted in time served at the resentencing. The occasion for compassion and sympathy are not limited to sentencing. These values require that all of the litigants who appear before us are entitled to respect as children of God. We are called on to treat the litigants, whoever they are, with the respect and dignity to which they are entitled. A considerable portion of our docket these days consists of litigation brought by individuals representing themselves, pro se litigants. Our attitude of respect should lead us to attempt to accomplish just results for all of these people, no matter how difficult it might be. After all, our oath requires us to administer justice without respect to person and to do equal justice, equal right to the poor and to the rich. Indeed, some of the most satisfying cases are those where a just result can be obtained for an individual who seeks modest relief, such as housing or government benefits or some immigration relief, if that is justified under the law. As one of my colleagues once said, we are in the process of dispensing retail justice. I am reminded of a speech I heard many years ago by a great New York State judge, Owen McGivern. The context of the speech was that New York City was weathering one of its periodic storms of financial crisis brought about by alleged too much expenditures. In the peroration, as I recall it, Justice McGivern said, "On that great judgment day, when the cities of the world are drawn up before the throne of God, and the good Lord tells the cities of the world to go to the left of me to damnation, or to the right of me for salvation, let them say then that we were too charitable. Let them say then that we were too kind to the poor and to the immigrant. Let them say then that we helped too many." The final value that I want to discuss is humility. The Bible is filled with injunctions to be humble. St. James writes, "Humble yourselves before the Lord, and he will lift you up." And St. Paul writes, "Therefore, as God's chosen people, holy and dearly loved, clothe yourselves with compassion, kindness, humility, gentleness, and patience." Humility means never being too sure of ourselves. I believe that my religion compels me to work as hard as I can to try to get the right answers to the issues that come before me. But I appreciate that I could well be wrong. After I've done the best I can, I'm happy to leave it to the Court of Appeals. Indeed, I tell litigants that one of the joys of being a district court judge is that we know that what we do is not final. Any seemingly final decision can be appealed to the Court of Appeals. What an awesome responsibility the Supreme Court has, knowing that theirs is the final word, including on issues of whether someone lives or dies. We know, however, that our decisions are always subject to appeal. Humility is part of the religious values that inform my worldview and hence my view of the law. How can you read the Bible and not be humble? After all, we know that we are all imperfect, striving for a perfection that will not be achieved in this life. We know that humility is a virtue, and even Pope Francis famously said, "Who am I to judge?" I remember receiving a letter one time before a difficult sentencing from a nun who wrote to me saying, "Judge not, lest you be judged." This was many years ago, I still remember it, and I thought to myself, if not me, who will impose the sentence? When he received the Learned Hand Award last year from the Federal Bar Council, Judge Calabresi reminded us of the words of the great Judge Learned Hand in his famous Spirit of Liberty speech, in which Judge Hand said, quote, "The spirit of liberty is the spirit which is not too sure that it is right," unquote. I remember in law school, north of here, my constitutional law professor, Archibald Cox, said, "Did the framers believe that wiretapping was unconstitutional? Hard to tell when they didn't have telephones." And I can argue it either way. In other words, when we talk about what the framers intended the dictates of the Constitution to mean, we should not be too sure of ourselves. Or take the constitutionality of the death penalty. It could be argued that the death penalty is plainly constitutional because the framers of the Constitution provided for the death penalty. The Fifth Amendment provides that no person shall be deprived of life without due process of law, plainly a contemplation of the death penalty. On the other hand, the Fifth Amendment also provides that no person shall be twice put in jeopardy of life or limb. Surely our Supreme Court today would not approve a punishment that provided for lopping off a limb. In other words, we cannot be too sure of our arguments or our ability to discern the correct answers. The decisions we must deal with are very difficult, and all we can do is do the best we can and reach a decision as best we can that we believe is consistent with the law and the facts. And humility is the opposite of arrogance. Remember the parable of the Pharisee and the tax collector as described in St. Luke. Briefly, two men went up to the temple to pray, one a Pharisee and the other a tax collector. Never good to be a Pharisee. The Pharisee stood by and prayed, "God, I thank you that I am not like other people, robbers, evildoers, adulterers, or even like this tax collector." But the tax collector stood at a distance. He beat his breast and said, "God, have mercy on me, a sinner." And Christ said, "I tell you that this man, rather than the other, went home justified before God. For all those who exalt themselves will be humbled, and those who humble themselves will be exalted." I'm reminded of a case that I had in private practice. The case was a complicated civil securities case. It was pending before a senior and very well-respected federal trial judge in the Midwest. At the argument of a motion, the judge told the lawyers that he had never in his experience had a case just like this. And he asked the lawyers how this case should proceed. I was struck then and continued to be by the judge's humility and at the same time his self-confidence. The judge was prepared to rely on the lawyers without attempting to pretend that the judge knew more than the judge actually knew. That judge continues to be a role model for me. What I've said is an effort to explain that religious values are part of the character of the judge and cannot be divorced from the judge. But religious dogma is not part of judging, and indeed is antithetical to the judge's obligation to follow the law as best the judge can determine what the law is. All of these concepts can be summed up so well in the words of the prophet Micah. Do justice, love mercy, walk humbly with thy God. Justice is fidelity to the law. Mercy is compassion for those who appear before us and recognizing God in all who appear before us. And humility is recognizing our human frailty and attempting to do the best we can. Thank you. You've been a very attentive audience.
Thank you so much. Thanks for your reflections on justice, mercy, and humility. We do have time for a couple of questions if you'd like to come up to the microphone. Just to begin, I think of Helen Prejean as you were speaking, who worked with people who were on death row, but then also realized she had to work with people whose families were victimized. So how do you balance the mercy between both victims and defendants?
I'm going to start with a question. First, thank you for a talk that showed really why you are a great judge. I have a technical question. In deciding your discretion in sentencing, say, do you take into account what you think was going on in the prosecutor's office? Do you look and try to see whether for some reason they went too hard, or whether for some reason, possibly their feelings that may be very bad about race, religion, whatever, they went too low? That is, in your decision, do you try to use your discretion to deal with a tremendous discretion that the prosecutors have in bringing the charges that they bring?
I'll answer both of the questions. When I was clerking for Judge Weinfeld made it a practice never to get input from the prosecutors. He didn't care what the prosecutors thought his sentence should be. He took into account the probation department report about the defendant and his own judgments about the nature of the offense and the defendant. So what the prosecutors were doing doesn't affect him. He looks at, and I'll transfer that now to me, I look at what the defendant has been convicted of. I make my judgments under the law about that the sentence shall be no greater than necessary for these purposes, and come to a conclusion. And I really don't care very much about what's going on with the prosecutors or what the prosecutors want. I have to live with the decision as to what the sentence will be. The prosecutors don't. Now, sentencing has, there are some issues that the prosecutors can have real input into. For example, what is the relative culpability of this defendant compared to other defendants in this or related cases? Very helpful. What is this defendant's level of cooperation with the government? Is it sufficient to get a 5K1 letter, as it's called, or even if it's not sufficient to get that, the very fact that the defendant has cooperated or attempted to cooperate with the government is an important factor. So there are some issues that the prosecutors can be involved in, but ultimately, I have to sentence this defendant for these crimes, taking all of the relevant factors into account. And with respect to the other question about balancing the rights of the victim and the victim's family, sure, you take that into account because it affects the crime itself, the severity of the crime. So we get victim impact letters. When there is a securities fraud, for example, and it's really quite the people who were injured are broadly spaced, and the individual harms in an individual case might not be that great, compared to another case where someone has actually defrauded individual people of their life savings, and they write you letters explaining what the result of this crime is on them. Those are two different situations. And of course, we have the sentencing guidelines that are the beginning of calculating a sentence, but certainly not the end of the process. And they just tell us where to begin.
First of all, thank you so much for your speech. I was wondering, have you ever been in a situation where the human laws come into conflict with the divine laws, which it also seems that we're bound to uphold? Whether there's been a time where you're forced to either strike at one of the branches of the human laws or of the divine laws, and whether or not that's the case, what would you do?
In over 25 years on the bench, I've never come across that situation. And in thinking about it, there are lots of escape values in our law, escape valves. So, for example, we have a due process clause. We have provisions of the Constitution that are there to prevent truly unjust results. So I've never come to that situation where I thought that I was faced with a situation where if I followed the law, I would be tolerating an unjust result. As I mentioned, if I ever thought that was the situation where I couldn't be faithful to my oath and at the same time come to the decision that's required by the current law, then the result is, I think, resignation. But I don't see that. Haven't seen it. I was once on another panel where we discussed that very subject, and I think that the result should be resignation. Thankfully, we live in a country where you would be surprised if there were a law that were so unjust that you would be faced with that prospect.
Thank you very much. And I want to ask a question about how Christian ethic and Christian teaching can contribute to a world that people really can taste that God is justice. The background of my societal situation is when the government is totally corrupted, and even the judiciary system can still be independent, but because of the investigation power is under the government, so all the case they put on the court is the like somehow oppression. So the judges can never in their court solve the problem of the first kind of violence, which is the systematic violence from the government, and they can just like judge all the people they doing the resistant violence. But when the police try to oppress this kind of people, that kind of repressive violence, they never be put in the court because the police is the one who investigate. And those crime and those injustice that over it's larger than a department of police, they never put in the court. And the judiciary system still think that they are doing the work of justice. And they didn't think that they are just a tools of a totalitarianism government regime to oppress the people, and how we can seek justice on this world and think that God is justice, other than something about final judgment.
It is one of the joys that privileges that we have to operate in a legal system in the United States, which is respected, and in which we can have trust. I fully understand that there are problems with other judicial systems. What can be done about that? American judges, including Judge Carney, who's here, are on programs that go to foreign countries and talk to foreign judges about the importance of judicial independence, the importance of the rule of law, and from time to time we have judges from abroad who come and talk to us and observe our judicial system. We hope that that inspires other judges throughout the world in very difficult situations. But I fully appreciate that there are real problems in judicial systems in other countries. So it requires a lot of work, help from us, help from international institutions, and the movement of the people in those countries. Yes.
Thank you again for coming this evening.
My pleasure.
It's ours too. 2 questions ago, you were asked about the clash between the absolutes. And I want to ask about the more common situation where the legislative or the judicial branches have carved out exceptions for religious beliefs under the Religious Freedom Restoration Act or the current Supreme Court jurisprudence of, if I may, using the First Amendment as a sword rather than a shield with respect to laws of general applicability and so on. And I wonder if, without putting yourself in an awkward position, you have a view about how we're doing in trying to strike that balance about the space for religion and its tension with civil law.
Your you're right to put the caveat that I don't want to say anything about specific cases. I always remember Justice O'Connor's instruction in an aid to religious schools case, Agostini, in which Justice O'Connor acknowledged the lack of consistent rationales in the various decisions. And so she said to judges, particularly, I think, to trial judges, don't look at what we say, just try and find the cases which are most like the case that you have and follow that. And, you know, that's what we do.
But my question is, how are we doing that, brother?
We try the best we can.
Thank you so much for speaking with us today. You spoke about...
By the way, you know, it's I say it's a privilege and honor to be here. That is completely true. I mean, all of you are the future. You know, you're the future of the law. You're the future of religion, and to have some input into that is a real gift. I teach at NYU in the law school and as an adjunct professor, and that's the way in which I end my class. I mean, you know, you all are the future, and it's such a real privilege to be here. So go ahead.
Thank you. You spoke about how your religious values teach you to follow the law, sometimes at the expense of your personal beliefs and values. Can you talk a little bit about the emotional and psychological toll some of these difficult decisions have on you and how you deal with them after the fact?
As I said, you work as hard as you can to try to be as correct as you can, and then there really is a release to leave it to the Court of Appeals. I tell my clerks, we do what we do, and they do what they do, and that's okay. In the area of sentencing, Congress has provided that you cannot change a sentence after it's been imposed, unless there's a clerical error or mathematical error. So you try to be as correct as you can, and you know that literally when you leave the bench, that's it. So you can't worry that night, gee, I could have added or subtracted a month. It's over. It's, you know, it's on. It can be on its way, and so you live with that. But in deciding what the sentence is, you know, I literally, you know, agonize over things like, should it be another month or 2 months or less, or to try and come out with what I think is exactly the right result.
Thank you for being here. I know I'm much too judgmental to be a judge, and you are completely fair. And that must be hard for most people to do. And that wasn't my question, though. My question is, if you observe or experience a very weak job by the prosecution or by the defense counsel, how do you have patience or judgment to know how to deal with that travesty? Thanks.
Sure. It's a it's a complex question because it really depends on the cases that you're dealing with. For example, if it's a pro se litigant in a case, you know that that person is not as skilled or skilled at all in the law, and you have a greater responsibility in order to make sure that what happens in that case is correct under the law. Similarly, if you find that there are presentations being made that are that where you should be doing something because it's not quite right, you'll do something. And in a criminal case, the government has an obligation to assure that if the defendant is doing something or not making an argument, that the government has an obligation to make sure that that argument gets made, because if there's error, the government doesn't want to live with a conviction in which there is error. If I think the government is making an argument that I think is just wrong, I'll point it out to them. And sometimes they'll agree with me, sometimes not. So, you know, again, you do the best you can, and sometimes, you know, even with good lawyers, I'll take them to the sidebar and say to a criminal defense lawyer, for example, you know, I see where you're going, and if you go much further, you'll have opened the door to all of this evidence that so far I've been keeping out. But, you know, it's your representation of your client, and the result of a conference like that usually results in no further questions.
Yep. Thank you.
Thank you so much for taking time to be with us tonight. All are invited next Sunday to our Graustein lecture on environmental justice, and I'd like to invite all the students to join Judge Koeltl up in Rig Study. If you go past the security desk and up the little stairs, we'll have further conversation up there. Thank you for being with us tonight.